But that's the new guy. I don't know who he is.
I didn't send you because I can't meet. I talked to him. What did he say?
Saturday.
Oh, that's good. What time?
I don't know.
Okay.
They're Evans.
They're what?
They're Frankel Evans. She has some issues. So they're in the States.
Oh, okay.
So they'll get back.
Okay, thanks, Lauren.
Okay.
Did you talk to them a little bit about it?
Yeah,
And what they said?
we'll get together.
Okay.
It's on.
We're going to start in just a minute, ladies and gentlemen. We're waiting for one more person who's supposed to be on.
Thank you.
I like this camera.
Did you check with them? Did you check with the number?
Jennifer, do you have an update?
He is going to be here. I talked to him during the day.
I just really don't want Ruth to get crucified. I just don't.
Hey, Anthony. Okay, ladies and gentlemen, we're going to get started now. I'm going to start with calling the meeting to order. Jennifer, you put it down that we started at 12:03. Roll call. Betty Barnett,
Yeah,
tell them who you are and what your address is, please.
that's 302 Darwin Drive.
Okay. Anthony Morello.
Here, 415 Birch Street.
Linda Williams.
3229 Hope Street.
And Michael Simpson. Will show that we do have quorum and all 4 members are present. First thing we'll start is the complaint filed against William by Scott Whitaker. Okay, Scott.
Thank you.
When you come, would you please identify yourself and your address for the record, please? If you're a lawyer, just identify yourself and tell them who you represent.
I'm Scott Whitaker, 3347 North Whitney Avenue, Hapeville, Georgia. And I wanted to say, members of Hapeville's Ethics Committee, legal counsel, all parties to this hearing, and to the public, thank you for taking time today to be here. I appreciate it. I'm here today to present evidence in support of my claim and my complaint against City Manager William Whitson. Hapeville's Planning and Zoning Manager, Bill Johnson, is responsible for approving sign applications. The city trusts him with this responsibility because for nearly 2 decades, he has been recognized as an authority on our codes and ordinances. Evidence of this lies in the fact that no city official, no
Scott,
mayor... Yes,
hold on 1 second, please. Before this goes any further, Mr. Whitson, would you identify yourself, please?
Mr. Chairman, my name is Gregory J. I'm here as counsel for Mr. Whitson, and we're ready to proceed. I don't know if you desire to hear from him as well.
Okay, thank you. And to let you know that the chair has decided that there will be a 5-minute opening comments on each side, and then we'll get into the court case. So you have 5 minutes, you can start. What you've said before is fine, you can keep going.
okay, keep going with that. Okay, fine. Okay, then, like I said, evidence of the fact that the city trusts Mr. Johnson with this responsibility is because for 2 decades he's been recognized as an authority on our codes and ordinances. Evidence of this lies in the fact that no city official, no mayor, council, manager has ever overridden a decision made by Bill Johnson, and our city has never been sued because of a decision based on information he provided. That's $0 in attorney's fees, 20 years. That's a pretty good record. So I'm here today because there is an application for sign permit filed by Main Street Partners that was not approved by the Planning and Zoning Manager, Bill Johnson, because he knew that the sign district did not allow for a 64 square foot sign as the application asked for, but rather would only allow for a 20 square foot sign without asking for a variance. I hold that Mr. Johnson, our City and Planning and Zoning Manager, whose judgment is impeccable in my eyes and probably a lot of other people's, held that that sign needed to get a variance to get approved, and the city manager apparently held otherwise because he approved it and caused that sign approval to be granted, the permit to be granted over the objections of our city planning and zoning manager. And I've seen evidence that he's also trying to remove him, that the city manager is trying to remove the planning and zoning manager from day-to-day operations like staff meetings and council meetings. And this man's voice is too important and too well trusted to be cut out like this. And for this, that's my basis of my complaint. I hope to prove that with my evidence and with my arguments that the city manager not only violated 3 ordinances by stepping around and approving this sign permit, but he also is working actively to circumvent a citizen board, the Board of Appeals, which should have been involved in the process. He worked to cut them out of the process. He cost the city a $350 fee that should have been filed as part of the application for a variance. He saved Main Street Partners time and money. But I'm here today because an ethical city manager does not have a reputation of being the guy in City Hall who can fix it for you. That's what's being demonstrated here. I'm approving that.
State your name again, please.
Yeah, Gregory J., law firm Chandler Britton J. I'm here on behalf of the city manager, Whitson. Good morning, board. Privileged to appear before you today. I represent a number of cities, and in that regard, salute your service. And you know, our cities and our local governments are incumbent on individuals such as you to volunteer and take part in the process. We think this matter is incredibly straightforward and simple. You're sitting here today as an ethics body to see if my client, Mr. Whitson, has violated any ethics regulations that's set forth in the ordinance. What happened here is pretty straightforward. There is a concept under Georgia law, which I'm sure your counsel can explain further, called vesting, which is when someone has a development, relies on approval, relies on a change in position, spending money, things of that nature, they become a vested use. Essentially, they're grandfathered. Even if the rules subsequently change a year later, if they have started that process, made investment, etc., then their rights are vested. And this is the case you have here. This project, in its first inception, around the time of recession, commenced. We can certainly show, and I can state my place, that it was approved and went before the Atlanta Regional Commission. Actually, an exact sign was erected in that location, and approvals by the city of Hapeville. And because those were approved, this subsequent developer, in the opinion of the city manager, can certainly rely on that, and those are vested rights. And we feel confident in that. But without even getting to that issue of vested, not vested, you know, the law allows him to make a discretionary decision. It even sets forth in your ordinance that, that the officials and employees have the power to exercise judgment in a decision or action. The evidence would show that he relied on others telling him it was vested, would relied on his own city council, and certainly, even if you get to the point of feeling this is a nuanced legal issue, he has the discretion to make that call. This is not the case where he has an interest in the development. This is not the case where there was undue influence. It's not the case where there's been any gift or any consideration to him. He is essentially exercising his function as essentially the chief officer, professional officer of the city, and feeling this is vested. So we think this matter is really outside the purview of the ethics ordinance. At the conclusion of this gentleman's case, we will be asking you to dismiss it, which you are allowed to do. And then finally, I would just add two quick comments. You know, we're not here in a personnel hearing. You know, the individual that inspects the signs works for this gentleman. I don't think we're getting into how good an employee is not. This is really beyond your purview. Second of all, the gentleman mentioned a $300 fee. I would argue just by this incident alone, the fact that the city has to pay for my time, the city has to pay for your counsel, the fact that all these people are gathered around tremendously eclipse any $350 fee. So I just think that's again, it was justified but somewhat disingenuous to talk about the city being cheated out of some $350 sign fee when we feel it's vested. Thank you for your time.
Thank you. All right, at this time, we'll hear testimony from Scott Whitaker.
Thank you. At this time, I'd like to present my Exhibit A. This is an application, copy of an application for sign permit, which was filed.
Okay, Scott, if you will listen, our lawyer's going to swear you in.
Okay, oh, certainly.
If you'll raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this matter should be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Thanks, this one.
All right, go ahead, Scott.
Okay. As opposing counsel mentioned, never mind, I'm not going to give him any more advertising. He's got his time for his own words. Anyway, Exhibit A. Note, if you will, that on the review page, the form contains an unsigned signature line, and the caption beneath the line reads, Planning and Zoning Manager. This is because for a very long time, applications for sign permits have been reviewed by the Planning and Zoning Manager. Also, please note that in Exhibit A, the review page shows the word approved, circled, and bears the notation, per William Whitson. And finally, if you will, please note the absence anywhere on the sign permit or the application of any mention of a variance having been requested or granted. 3558 Elm Street, referred to in Exhibit A as job address, is in a commercial mixed-use sign district. And according to Hapeville City Ordinance, Section 93-3.3-17, sign standards by signage district, the largest sign allowed in this sign district is 20 square feet. The size of the sign on the application in Exhibit A is clearly stated to be two 8-foot by 4-foot signs totaling 64 square feet. In the normal course of obtaining a variance for a non-standard sign, an applicant must apply to Hapeville's Board of Appeals. See Ordinance Section 87-3-5C, little c, appeal for a variance. And notice of a public hearing must be posted. See Ordinance Section 87-3-6, public hearings on appeals. A fee of $350 must accompany each appeal for a variance in Hapeville. Why this client was never advised to just appeal for the variance, since they have made the application in May and are just now getting their approval in August, I don't know why, because as the attorney did say, I look at the money they're having to spend today to defend this because they didn't spend $350 up front when they should have. And it shouldn't have been money the city had to spend anyway, but the applicant. So the city should not have to spend any money there. They shouldn't have to be having to spend money today, but they are. And it's because the procedures were not followed. So, as can be inferred by the notation per William Whitson on the permit review, as well as the signature on the signed permit itself, City Manager William Whitson improperly approved what Hapeville's ethical planning and zoning manager had not approved. By his action, City Manager William Whitson denied the public a hearing and defrauded the city of the uncollected fee, and also resulted in additional fees being incurred here today. As Main Street partners were saved time and money, the action of the city manager has the appearance of preferential treatment. Sign permit number 082032 in Exhibit A was granted on August 16, 2016, signed by City Manager William Whitson. Okay, now I've got Exhibit B.
Thank you, Don.
Exhibit B is the sworn affidavit of Mr. Joshua Patton, dated October 10, 2016.
Mr. Chairman, I'd like to interrupt.
Yes.
The ethic ordinance provides that to the extent any evidence or any items would be presented, they would be furnished to the body and furnished to council. I think it's 5 days prior to the hearing. We've not seen this. I mean, I'm not overly concerned, but I think under your rules and procedures that this gentleman is so wanting everyone to follow, that this evidence is inappropriate and should be not allowed.
Thank you, just 1 second. Do you have the information showing that this was submitted to the parties 5 days prior to today's date?
None whatsoever, but I would ask that if that's the case and these are going to be unadmitted, then I would ask for a continuance for 45 days so we can make that happen, because I was unaware of it at the time.
Mr. Chairman,
Yes.
in addition to the time requirement, the ordinance also provides that the person that's been accused has the right to confront their witnesses. This is merely an affidavit. This person is not here testifying live, and in matters such as this is not allowed in any event. So even if we forget this 5-day rule, it wouldn't be admissible today.
Okay.
I'm fine with that.
Scott, unfortunately, and I'm going to have to make a decision as the chair. We can
Sure.
vote on it if you all would like, but this is inadmissible because it was not sent to them 5 days prior to this. It is in the ordinance.
Okay.
It has to be done. So, and they also have the right to cross-examine as well as cross-examine you. So
Not a problem.
it's not able to use this particular.
Okay, I want to, if I could respond, I just wanted to point out that Mr. Patton's presence here today would be a hardship because his ankle is still in a cast that, from an injury he got from a compound fracture when he was run over by someone attempting to kill him when they were robbing his property less than a month ago. He had a gun with him at that time because he knew these people were coming back. Fired back, but what he did was he fired at the car, disabling the car, forcing the suspects to flee on foot. The Hapeville police has the name of the person, they've got a photograph, they've got the name of the car, they've got his driver's license. They have not made an arrest. At this point, though, Mr. Patton being here would have been a hardship because he's been told to stay off it. But if you'll grant the continuance of 45 days, he'll show up in person and testify.
Yeah, unfortunately, we can't grant the continuance, and we're going to have to deny the existence. So if you guys will take Article B, Exhibit B, and turn it upside down and put it up here, it cannot be used. You can continue, Scott.
So there's no issue with Exhibit A? Even
No,
though I
because
did not...
Exhibit A is everything that was contained in the original complaint. Therefore, it is admissible because that was sent immediately and they got it 5 days prior to that. But other than the pages that you did, because if I remember correctly, and if anybody on the board wants to correct me, I believe these are the only 4 pages that we received in your complaint, as well as the original complaint itself.
Okay.
And that's the only thing that will be admissible here today.
Then they'll cut a little bit more, cut more time out of my presentation, so that's fine. It's probably a win for everyone. Okay. Do I continue then? All right then, with the exception of the additional exhibits that were going to be presented here, and that's just my ignorance of the process that's that's unfortunately they don't allow those to be disallowed, but nonetheless, let's see where we have to go to now. Okay. Well then, let me just make the argument that Bill Johnson, like I said, has been here 20 years. He's an asset to the city, not a liability. He's an asset in many ways. Number one is he's written, not only does he understand city ordinances and codes, he's actually written some. He wrote an ordinance in 2013 that prevented parking lots being constructed on Virginia Avenue, and that's just held up for a second time. So that it was challenged. So he's an asset for the city, not a liability. I just wanted to say that I can't understand why anyone would want to undercut the authority of a consultant like Bill Johnson, who has a perfect record of interpreting the city code and ordinances. And that's in public records. There's never been a single suit brought by information based on information I've gotten from Mr. Johnson. He's always been able to provide just the facts, and that's always what he's done. So, no lawsuits. And, not one dime in attorney's fees ever having to defend any of his positions. So, goodness, okay then, all I can do is make the final argument. If allowed to stand unremarked upon.
1 second. Before you do your final argument, do you have any questions for the complaint?
None at this time.
Okay. You can go ahead and make your final statement.
Okay. If allowed to stand unremarked upon, City Manager William Whitson's decision to bypass the Board of Appeals will leave the city liable to lawsuits from everyone who has ever had to pay $350 for an appeal for a variance. Hapeville City Code does not allow the city manager to bypass a vital citizen board. The citizen boards, as you know, are an important part of how we run our city. They also don't allow him to waive a fee and grant a variance on his own. That's not in the code. Like I said, being a friend in City Hall who can fix things is not the reputation an ethical city manager would have. And that's what we're here today, is hearing about ethics, ethical behavior. Bill Johnson has demonstrated good judgment in his decisions as Hapeville's planning and zoning manager, and decisions based on his knowledge have never gotten the city sued. City Manager William Whitson's circumstances are arguably otherwise. There's something wrong in our city when this city manager, who had never approved a sign permit for us until recently, has the power to veto the decisions of our ethical planning and zoning manager and strip him of his responsibilities. Minutes will indicate that there has been an absence of our planning and zoning manager from recent staff and council meetings where he had always been in attendance before. This has the appearance of City Manager William Whitson actively working to remove a dissenting voice. As members of the Ethics Committee, you base your judgment in part or in full by what's best for the city. Bill Johnson has been a valuable asset for Hapeville for over 20 years. 20 years, $0 in legal fees. William Whitson has been the city manager for less than 3 years. How much has Hapeville spent on attorneys in that time? Just look at today. The actions of City Manager William Whitson create ongoing legal expenses and increased liability for the city. So that's why I'm here today, to ask you, my fellow citizens, members of the Hapeville Ethics Committee, for your help in making a simple business decision, asset or liability. I humbly request that you find City Manager William Whitson guilty of acting to knowingly violate Hapeville City Ordinance Section 93-3.3-17, Hapeville City Ordinance Section 87-3-5C, and Hapeville City Ordinance Section 87-3-6. Guilty of acting to prevent Planning and Zoning Manager Bill Johnston from performing his duties. Guilty of acting to intentionally circumvent Hapeville Citizen Board of Appeals. Guilty of acting to deny the public a hearing on a zoning variance. And guilty of allowing his personal feelings to adversely impact his actions as city manager. He should also be held responsible for paying back the $350. Oh, and one last piece of evidence that, since I couldn't present it anyway, he's done this application for a sign permit at Dearborn Plaza under identical circumstances. City Planning and Zoning Manager would not sign off on it. He did. That's all.
Okay. Mr. J, do you have anything that you want to present to rebut the thing?
Yes, Your Honor. And we are prepared, if necessary, to put on some brief evidence and to call Mr. Whitson. However, your ordinance expressly allows the matter to be dismissed after the complainant's case for insufficient evidence, and we feel that is certainly the case here. You know, really, what he is even accused of, I think, is even outside, again, the purview of the ordinance. If you look at the various standards of ethics, conflicts of interest, undue influence, things like that, that's not even what's addressed here. You know, again, this hearing is not a referendum on this Bill Johnson's credentials. I mean, he may indeed be a fine individual. I don't know the individual, but again, here, this is simply in the course of his job, a discretionary decision to feel that this project was vested after being previously permitted. You know, we've got evidence where the exact sign was present years before. And this is the nuts and bolts of city government, of making these decisions and doing these things. So I guess at this juncture, we would ask you to dismiss this complaint for lack of sufficient evidence.
Do I have a motion from the board? Whether he's asking if we can dismiss, do I have a motion to dismiss based on the fact that what they're saying is that with the testimony that you've heard at this point? Or do you want to hear it more?
I want you
Okay.
Okay?
Can you present some information?
Yeah, we'll proceed then.
Thank you, sir.
We'll call Mr. Whitson in a second. This we've marked Mr. Whitson's Exhibit A. Now I have him identify these. Actually, you will.
Yeah, Mr. Whitson, if you'll raise your right hand. Do you solemnly affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Witnesses now sworn, sure.
Mr. Whitson, you'll state your title to the board.
Yes, my name is William Whitson. I'm the city manager for the city of Hapeville.
And in that capacity, do you oversee and have the final decision of all department heads, employees, independent contractors?
I do, sir. Okay.
Do you have occasion to call the sign application that's been tendered as Exhibit A by Mr. Whitaker?
I do.
Okay. How did you come to, well, let me ask you, did you indeed make a decision that this sign was appropriate and should be permitted?
I did.
Okay. How did you come to make that decision?
It's no secret that Bill O'Brien has been trying to develop this property for many, many years. The only reason he stopped was the recession. And we are in active conversation with Mr. O'Brien. Mr. Johnson's well aware of that fact. We've been trying to get that development restarted again, and in fact had to go back due to recent Supreme Court rulings and update our sign ordinance to allow construction signage to advertise various developments that are coming, because content-based regulations are outdated. So Mr. Johnson was involved in all those conversations with me and with the rest of the staff, and he's well aware of the fact that these developments are out there and that they're vested. And in fact, I've participated in multiple meetings with him regarding the same.
Let me ask you this, sir. You were not in the employ of the city at the time this project was initially submitted many, many years ago.
I was not.
Okay. Have you, or did you come to learn that the project was approved by the ARC, approved by the various departments within the city of Hapeville?
That is correct. The entire file is available for my review, and I did ask the staff who has the record to reveal to me what approvals were in play. And this development has what they call a DRI, which is a development of regional impact. And those DRIs, once they're issued, are good for 10 years.
Okay. And I've handed the board what we marked as Exhibit A. Could you identify this first picture?
Yes, this is a picture of a sign that Allie O'Brien, who's been with the staff for a long time, provided to me, that was designed and actually was a joint sign that the city was working with Mr. O'Brien to put up at the project site, near the project site, back in, before the recession, sometime between '08 and '10, somewhere in there.
Okay. And then following out are pictures of what I'll describe as the orange sign, mixed-use development. Is that the sign they're seeking to erect that we're here about today?
That's correct.
Okay. And it's your understanding that this top page, the coming soon sign, was approved and erected prior to the recession or during the recession?
Yes, sir.
And what is your understanding of vested rights?
My understanding of vested rights is that once a developer has the right to proceed with the project, has gone through the appropriate permitting process, that right remains with him until withdrawn. And in the case of Mr. O'Brien, he's under an active DRI until sometime in the summer of 2018.
Okay. Notwithstanding your own determination, did your city council voice any direction as to the sign?
Yeah, they want it up. They told me, make sure Mr. O'Brien gets the sign up because we want the development.
Right. So, would it be accurate to say that in your opinion, based on vesting, there would be no need for variance?
Not in my opinion, sir.
And if there's no need for variance, that would not come before a separate body?
It's an administrative decision. It's not something that, needs to be carried through a bunch of different processes.
And as the, maybe not the CEO, but as the top operating official for the city, in your duties, are you called upon to seek counsel or to make decisions that are in the context of have legal ramifications, things of that nature?
Do it every day, and Mr. Johnson works for me.
Okay. That's all I have for this individual.
Mr. Whitaker, do you wish to cross-examine?
Yes, I do. Thank you very much. 2 seconds. Just from back here? Or? From
That's
back? Okay. All right then. The first question, Mr. Whitson, do you believe that the citizens' boards in Hapeville perform a vital function?
I do.
Okay. Were you aware that by approving the application for sign permit number 082032, you were violating 3 city ordinances?
I wasn't violating any ordinances.
I beg to differ. Did you cause to have issued a temporary sign permit for Dearborn Plaza?
I did.
Were you aware that the planning and zoning manager refused to approve the application that led to the sign permit being issued at Dearborn Plaza for the same reasons?
Let me object just to the extent, I believe that's a different development that we're not.
Yeah, we're not
Yeah,
here.
I retract the
Go back to
question.
this, Scott.
I retract it. Have you changed any more decisions made by the planning and zoning manager?
Yeah.
Same objection.
Oh, I don't know about
We got
that.
to keep it to this, Scott.
Then I have no further questions.
You want any closing arguments?
Yes, Your Honor, thank you.
Go ahead.
Okay. In closing, again, this was a discretionary decision. I mean, one we feel that was legally correct, that he was bound to do, that if you want to talk about litigation and rights and property rights, that if a developer, someone who purchases land, has changed their position, has had prior approval of permits, things of that nature, that they can rely on that and fall under that. And that was certainly what he was doing. You heard from the city manager that he was relying on that. It actually, you even heard that his counsel instructed him to do it. But more than that, there is this notion of vested rights and prior approved and things of that nature. And again, it was a discretionary call. There's been absolutely no evidence of any bias toward this developer, any undue influence, any benefit that my client received. Again, I mean, he's been a city manager for over 30 years. This is his first ethics complaint, and we have to take it seriously. I mean, we're here not essentially involuntarily. I mean, this gentleman brought this. It's incumbent on him to prove his case. He has the burden under your ordinance, and there's been absolutely no rebuttal at all, or no contrary evidence that this development did not have vested rights, was not approved previously, or anything of that nature. And given the evidence before you, given the four corners of the ethics ordinance and what we believe your charge is, we think that matter should be dismissed. Thank you.
Do you have any rebuttal evidence to present, Scott? It would have to be evidence in Exhibit A.
Other than what I've already stated, it's already been allowed in, and that is that Bill Johnson has been doing this for 20 years. It was his opinion that Mr. Whitson's decision is incorrect. That's the rebuttal I've got right there.
Mr. J, do you have anything that you want to present evidence to rebut?
I would only say again that again, there's a lot of talk about Mr. Bill Johnson. That's somewhat clouds the issue. I mean, if at the end of the day, this man is in charge, this man works for the city council, and he's responsible for those decisions, and he made what he thought was the correct decision. Period. Thank you.
We'll close that section. We're going to go on. Does anybody on the board here have any questions for Mr. Whitson or his lawyer, or for Scott?
I do for Mr. Whitson.
Mr. Whitson, am I, this, that sign,
Yes, ma'am.
okay, and he did that back in '08?
Ms. O'Brien indicated that that was before the recession, somewhere in that time.
Okay, and I remember that.
Yes, ma'am. Because the city and Mr. O'Brien have long been working together.
Yes, okay,
And parts of his development is already up. You can see it, walk out the door and see it. And
okay.
the only reason he stopped was because of the recession.
Is this sign right here bigger than the one that's here?
It's about the same size.
I started to say, they look, I remember,
Yeah.
they look a lot. Thank you.
Can I ask a question based on that? So these signs, you said pretty much the same size. Did this one go to the appeals process?
We don't know because it was 10 years, it was 8 years ago, but it did go through the process of some sort.
It went through the process at that time.
The process, whatever it was at that time.
Yeah, if I can, just 20 seconds to clarify. If you have a metal building in town and this council decides that metal buildings are not allowed, the buildings now have to be built with brick, stone, what have you, that metal building does not have to be torn down. It is what we call a grandfathered non-conforming use, because it was built under a prior time when it was allowed. And that is exactly what we say our fact pattern is, that while we may have, Hapeville may have adopted a new, more restrictive sign ordinance, when this project was permitted and when it was initially done and approved, the sign ordinance allowed for this, or in any event, the city allowed for it. So the requirements under any new ordinance would not apply to this sign.
So the question, I guess, to you, to your knowledge, this was a correct sign at the time?
It is my opinion that it was a correct sign, yes, sir. And I was trying to be consistent.
Anybody that's a member of the board have any other questions? All right, at this time, we'll close the hearing, and we'll open it up to the members to deliberate and make comments. Okay, so do I have a motion? Okay. I can open it up to a vote. Do you think we need any other additional information or to make a decision on this?
Is it, Bill Johnson name came up.
Yeah, but the meeting is about whether,
I know,
This
it's
side.
interesting to me to figure out why he didn't.
okay,
Because according to the evidence I heard, he's approved most of the signs. And why this one, he didn't approve.
okay.
If Bill Johnson's been working for the city for 20 years, he approved this.
Go ahead and say that.
Out loud? Yes.
Yeah.
If I can stand to be corrected, but if this was approved in '08 or 10, Bill Johnson was the city,
Planning and zoning manager.
yes. So Scott, therefore, he approved this.
He
If he
approved it
did.
the first time.
He approved it the first time. So I don't understand.
Only if there's paperwork. He may not have. It could have been another city
So
manager.
Scott, you can't.
I'm sorry,
This is,
but-
we're in, that part of the hearing is closed, we're in discussion.
I apologize.
with you. So this is, you're saying that to us.
Okay.
We're carrying on a conversation over this. So I kind of agree with her.
But
It's, it had to have been approved
Yeah.
somehow, because I remember when the sign went up, I remember when they bought that, I lived here
no
during that
doubt, no
procedure.
doubt about Bill being a fine person, has done our city well. But, and that's a large parcel of land.
Well, yeah, and the thing is, whatever process they went through that back then, that process still applies till 2018,
Yeah.
and we're under that limit, so
That's right.
therefore, them saying that the sign was incorrect is not fair, because he was allowed to do it, he had the sign up, things went south during the recession, everybody stopped, the sign came down, but he still has the right to put it back up, and he did go through the process of filling out the application and stuff to get it back up.
So it's more or less grandfathered in.
So, the charge is that Mr. Whitson did this outside his purview as the city manager, and also did it incorrectly, where it looks like the evidence says that this sign was approved somehow by Bill Johnson the first time, and now it's not being approved because there's stricter rules, but because it's the way it is, they had that right to put that same sign back up, the same size and all that kind of stuff, till 2018. Do you have any other? So we need to put it to a vote. If you feel that we have enough information here to go ahead and rule on this with the information we have at this time. So all those that feel that we have enough information, signify aye and hold your right hand up. Aye. Opposed? Okay. Vote carried 3-1. this time, we'll open it up to a vote to see if Mr. Whitaker has proven with the preponderance of evidence that Mr. Whitson has violated what he should have done and has overstepped his bounds. So those that feel that Mr. Whitaker has shown enough information to say that Mr. Whitson is guilty, signify by saying aye. Those that do not feel that there's enough information here to say that Mr. Whitson is guilty, that he is not guilty, signify by saying aye. Aye. Raise your right hand. Okay, 4 to 0. At this time, the hearing is now closed. We'll take a short recess for lunch, and we will come back in 30 minutes, which I believe will be 20 after, and we will start the second hearing.
Thank you.
Thank you.